Okay, so last class session, we left off with the Everglades and the Miccosukee tribe case and the fact that the EPA adopted a unitary waters rule as part of its water transfers rule. Okay, so water transfers rule, unitary water policy, which basically says that when water is transferred from one sort of subunit of water to another, from one water sort of sub-body to another, and nothing is done to it. I mean, it might go through a conduit of some sort, a pump, a pipe, or something, but there's nothing added to it. Even if that water is polluted, it is not a discharge of pollutants into waters of the United States. So that's the rule that the EPA adopted in, I believe it was 2008. It has been challenged. There were some lower court rulings, some federal district court rulings that invalidated the rule, but the appellate courts have reversed those trial court rulings and have deferred to the agency using Chevron deference. Okay? So what had happened is the trial courts had said the Clean Water Act is ambiguous. Okay, step one of Chevron, right? The Clean Water Act is ambiguous, but they said, that the agency's interpretation was unreasonable. They said the agency's interpretation was unreasonable. The appellate courts said, well, okay, yes, we agree that the statute is ambiguous, but the agency's entitled to deference, and this is a reasonable interpretation. Right? That they basically, the idea that you are not actually discharging into waters when you're simply moving water from one area to another. Okay, so that's so. In the Supreme Court declined to take the Second Circuit. It was the last case on it was a Second Circuit case, and so now it's pretty uniform across the country now that the unitary waters policy for water transfers is the interpretation by the EPA. So that's been upheld. Okay, so little Chevron deference going on there. Part of what's going on with that unitary waters issue is, certainly addressing the question about what constitutes a discharge of a pollutant, but it also starts getting us thinking about what counts as waters of the United States. So we briefly touched on that earlier with the Clean Water Act, but we've been sort of holding off at really addressing that because the issue comes up very intensely in the area of wetlands. So one of the things that the Clean Water Act does is it aims to protect wetlands from degradation and development, because development of wetlands is the addition of dredge or fill material to waters of the United States if the wetlands are considered waters of the United States. And so that's the question, is which wetlands are. This is section 404 of the Clean Water Act, and there's an entire regulatory scheme embedded just in section 404. And the authority, primary authority, unlike the rest of the Clean Water Act, the primary authority is in the U.S. Army Corps of Engineers. U.S. Army Corps of Engineers, because the U.S. Army Corps of Engineers was historically the agency charged with dealing with dredging of waterways, of waterworks that were, building of docks and marinas and that kind of thing along our waterways. And so they have primary authority. The EPA has secondary authority, and as you will see, it includes the potential to veto, the authority to veto a permit that has been issued by the Army Corps of Engineers. The whole point of 404 is to address a serious problem in the United States, which has been the historic loss of our wetlands. And so here's some pictures. This is these are the shorelands near the Great Salt Lake in Utah. I'm not exactly sure where this is. I think this is in the northeast. This is out at the parklands of Floyd's Fork, right beside the walking trail, and this is the Florida Everglades. This gives you a little bit of a visual of freshwater wetlands, so you can see rivers and streams, ponds, bogs, swamps, marshes, wet meadows, and vernal pools. A variety of different types of wetlands. It is not, I want you to sort of get a feel for the fact that there are various types of wetlands, but you don't have to master this. This is, this is really more ecology and hydrology than it is law, but I want you to get a feel. This actually comes from the US EPA, and I think actually the Army Corps of Engineers has a publication similar that identifies the various types of wetlands. But, when we talk about marshes, right, so that is a variety. You can have tidal or coastal marshes and non-tidal with fresh water and wet meadows and that sort of thing. Swamps are yet a different type. Bogs, and then fens. Fens, by the way, are what makes them different is that they are the water comes from springs from groundwater bubbling up. So all the way, all the way back from the early history of our nation, wetlands were viewed as something bad, where they were sources of mosquitoes and malaria, and they interfered with productive use of land, right? I mean, they were wet and swampy, and had all sorts of dangerous things living in them, snakes and whatnot. And they also were fertile land that could be turned into farms, that could be developed alongside rivers and streams and lakes and that sort of thing. And so in the early part of our nation's history, in the sort of colonial and early republic period, you actually might forfeit ownership of your land to the government if you did not fill in wetlands. Okay, so there were actual property forfeiture laws. All right, so we have all this sort of theory about private property rights and the intent of the founders and blah, 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 blah. But really, at the time of the nation's founding, private property rights were more vulnerable, because if you didn't do certain things that served the public benefit, you could actually just plain lose your property to the government. And that included these forfeiture laws for failing to fill in wetlands. And they viewed wetlands as being bad. And so there's this case from 1900, U.S. Supreme Court case, Levy case, where it says that the police power is never more legitimately exercised than in removing the nuisance of wetlands. Okay? So that wetlands were viewed as a nuisance. Okay? Now we know, so this you get almost a century later, the Supreme Court says, well actually no, this is the Seventh Circuit, but the Supreme Court's bought into this as well, in Hoffman Holmes, that wetlands are not nuisances. They're incredibly important to human beings, to wildlife, to ecology, to a society, to our economy. wetlands promote biodiversity. So most of our fisheries, most of the part of our economy that is based on fishing and all, depends at its core on wetlands. This is where the food chain starts. And so if we don't have wetlands, we don't have fish, we don't have, the whole food chain itself sort of falls apart. Okay, so wetlands are very important in that respect. And that's, I don't know, I can't remember the number off the top of my head, but zillions of dollars to the economy. Okay, but more broadly, biodiversity generally. Migratory birds depend extensively on wetlands, but all sorts of species. Wetlands filter pollution. They store carbon, so they are actually important carbon sinks for the purposes of moderating climate change. So when we get to talking about climate change, we're talking about causes, and then we also want to talk about things that can be done. Obviously, reducing our emissions of carbon to the atmosphere is one part of it, but also increasing the amount of sequestration of carbon. Sequestration means that we're storing carbon. Okay, so trees do that, but wetlands play a big role. By the way, you hopefully noticed this earlier, prairie grasslands also sequester carbon. Okay, so just point that out from our earlier study. Wetlands moderate water flow and store water. They store floodwaters. Okay? So wetlands are, and then finally they control erosion. But especially when we think about the storage of floodwaters, the holding of floodwaters, and the filtering of pollutants from those waters, you can think of wetlands as nature's sponges and nature's kidneys, right? So they're filtering out the bad stuff. They're absorbing all that floodwater. And actually, let me just point out while we're here that while we're talking about it, that obviously the breaches of the levees around New Orleans during Hurricane Katrina caused the flooding, but one of the major reasons why those levees were under such great stress was the loss of those coastal plain wetlands in and around the New Orleans area, which meant that you had reduced the amount of water storage that nature was providing in that area, right? So nature now normally provides for the flood waters to be held that way. That doesn't mean there's not going to be any flooding, but you won't have that kind of intense flooding that we saw, but we had lost a lot of those. So this is a graph that shows the loss of wetlands just between the 1950s and the 1990s. Okay, so that's a 40 to 50 year period.
Maybe true.
Okay, so if we actually go back further, right, we can look at the loss of wetlands since 1776, for example, to the present. It's enormous. Right, we've lost a lot of wetlands, but just even from the 1950s to the 1990s, we went from actually, I take that back. Okay, I take that back. That is not this graph at all. Sorry. This graph actually is about how our annual net loss has decreased over time. Okay, this is our annual net loss. So during the 1950s and 1970s, we were losing almost 500,000 acres of wetlands per year to development and so on and so forth. And then by the 80s and 90s, we were down to a loss of close to 60,000 acres of wetlands. But now think though about the cumulative impact of that, right? I mean, so we've been filling in wetlands since Europeans started settling North America, right? And so you have this enormous acreage loss. So we're slowing the loss, but we still have a net loss every year, right? Okay, so that's the issue. Now, hold on, let me just say one other thing though. In the early 90s, the President George H.W. Bush, the first Bush, adopted a no net loss policy for wetlands. Okay, so part of this was the official adoption of a policy that says we are aiming to have no net loss of wetlands. Okay, we'll talk about what that means, but that was a big step forward because previously we've been certainly reducing our net loss, but we hadn't actually adopted that as a policy. Jimmy.
Has the reduction in wetland loss been at least in part because of the reduction in overall wetland amounts in the U.S.?
Partly, but there's still plenty to fill in. It's actually really in large part due to the Clean Water Act. Okay, so this is one of the things that you can talk about. To what extent does the law actually have any impact? And I think the bottom line here is that if you think that the Clean Water Act is going to ensure that we protect all of our wetlands, that we don't have any net loss of wetlands at all, etc., you are way overly optimistic, right? You have too much faith in the law, because that is not true. On the other hand, if you are the pessimist and you say, oh, well, this doesn't have any impact, this is just a bunch of regulations that don't actually protect the environment, they just create this sort of bureaucracy, or we're allowing too much development and it's just we're still losing all the wetlands just as we always were. That's not true either. Okay, so in other words, we have seen improved practices, and yet we also continue to see wetland loss. Okay, so it's both and. And by the way, side note, I just got something a few days ago about a species, and now I can't remember what one it was, so I apologize, but it has come off the endangered species list because it's a success story. It's actually been recovered. Okay, so that's the glass half full. The glass half empty version of it, though, is that it is what we call a conservation-dependent recovery. The reason that it has recovered, and the only way that it's going to continue to stay off the endangered species list, is because we've taken certain proactive conservation measures to try to keep it from going extinct, right? So do you see a sort of glass half full, glass half empty? Okay, and so that actually is going to be much of what we see with with environmental law. Okay, another example. Okay, so and this is a side note, but we're not really doing the Clean Air Act. But if you were to look at hospitalizations and illnesses, actual air quality data, and photographs of Los Angeles in the 1970s and 1980s, and compare them to now, okay, LA's got a lot of people, it has air quality problems, but the air is much better. It's much better, even though it's still very auto-dependent, much better. And why? Because of the Clean Air Act. Okay? The Clean Air Act is the key factor that has led to, we no longer have lead in gasoline. Right? Okay, so I mean, just think about this, that there was a time in which everybody was exposed to lead because it was in the air, because it was in our gasoline. Right? I mean, most of you can't remember that, but I remember as a kid, there was lead in gasoline, right? I mean, that was just, that was part of it, right? And so actually, anywhere near highways, there is lead in the soil. Okay? Just be aware as you go out and practice law, if you're talking about some, farm out somewhere or other in the strips of the soil on either side of the highway, there's going to be elevated amounts of lead because people drove cars that emitted lead into the air for a bunch of years. I mean, for a long time. And so that's just, but other sorts of things, improved emissions and so on and so forth. So the point here is that the environmental statutes and the regulations and the regulatory schemes that go with them do make changes. They do cause improvements. Now, we can ask, at what cost? We can ask, are they enough? There's lots of ways of looking at it. Again, half full, half empty. But to sort of say, well, they don't do anything is just not accurate. And so that's, and this is an example. So here's another, here's some more information. So we actually, from 98 to 2004, had a net gain of 191,750 wetland acres, but then from 2004 to 2009, we had a net loss of 62,300 acres. Some of that had to do with Hurricanes Katrina and Rita, which caused more than 130,000 acres of wetlands to be lost. Okay, so the destruction of the structure of the wetlands from the hurricanes. Okay, so what that says is if we had not had these major hurricane losses, we would have actually had a net gain. How's that happening? It has to do with restoration. Right? Restoration activities. We are creating new wetlands, and we are restoring degraded, non-functioning wetlands to some sort of function. Okay? And that's what's going on. And so that's a positive thing. However, there's a sort of a cautionary note here about those hurricanes. From discussions that we've already had that we are going to see more and more destructive major hurricanes, where that's already happening. We're well past, Katrina and Rita, and we've had other losses of wetlands, right? And so forth, because we have these major hurricanes. Climate change will change this dynamic. It will interfere with our efforts to have net gains. Another sort of problem has to do with the fact that this is just all about quantity of wetlands, the amount of acres. When we actually talk about wetlands, what wetlands do for us, their function or their value is much more important. Okay? And so that's one of the challenges here, is that we're not really measuring whether these wetlands are producing the kinds of functions and values that the wetlands we've lost did. Okay, so what happens is we have these natural wetlands, these nature-created wetlands. We build or develop or fill them in, and to offset that, to mitigate that loss, we create new humanly created wetlands. And in general, there are two characteristics of the newly created wetlands that usually, not always, but usually make them less useful. One is that they are in locations that are different than the ones that we developed or have lost, right? So the newly created or restored ones are in other locations. So one of the things we know in Florida, for example, is you have all these losses of wetlands along the coast, which have really significant benefits in terms of protection against hurricane, storm surge, erosion, etc. And instead, what we have is the offsetting, the mitigating wetlands are inland, okay? And so they don't, they're still valuable, but they're not as valuable. They don't produce the same kind of functions. The other thing, so that one is just location. The other is that in general, human-created wetlands fail at a greater rate. So yes, we might have those acres, but 10 years from now, those wetlands may be non-functioning or poorly functioning. They may have failed. Why? Because it's very hard to create something that nature created, to make it work the same way, right? Okay, so one of the sort of classic examples is that I did a study with a couple of my students and some other researchers of the Anacostia River watershed in Washington, D.C. and Maryland. And that was a highly degraded urban watershed tied up with a lot of social justice and racial injustice issues, with slavery and segregation and the use of urban renewal to drive out low-income black people from their neighborhoods and develop it up. And so it also included with that, a lot of development of the wetlands and a lot of pollution, industrial pollution that ended up in the waterway, okay? So it was toxic to come into contact with the Anacostia at one time. And they had the most fish cancers of any waterway in the United States at one time. Okay, so it's really polluted. Over time, there has been a massive cleanup, and many of the efforts to engage the low-income and African-American neighborhoods have been tied up with the whole idea of conservation and restoration. So a lot of restoration activities and a lot of planning and protection and cleanup and so forth. And so one of the things that came about as part of that planning process, so watershed governance, which we're going to talk about on Wednesday, was that they decided to restore these historic wetlands in the DC area on the Anacostia, and their first efforts failed miserably. Why? Because the river itself is so much more shallow than what it was in 16 whatever or other when some British explorers sailed down it or whatever, right? So historically, there was much more water depth, which then meant that the soils were different, right? And so now you have all this sediment that has come off of all these tobacco farms throughout the 1800s, and then all of these sort of toxic soils and toxins in the soils that came off from the industrial development and the suburban runoff and all that kind of stuff. And you have all that, and it's made the river shallow, but it's also changed the dynamics of those wetlands. You can't just plant the same stuff. You can't just add, add water to the land and make it work the same. So what they've had to do is step back and redesign the wetlands to be something other than natural wetlands. Whether you call them restored or not, they're not retro, right? You're not going back to something that used to be, because it's simply not humanly possible to recreate what was, okay? You cannot recreate what was, so you have to create a different kind of wetland that will function under the circumstances, okay? So your choices are something new that works, or an attempt at a retro, sort of a retro wetland that fails. And those are the two options. And so that tells us that, for one, allowing wetlands to be destroyed ends up producing overall a net loss in function, even if we end up mitigating the acreage loss. So Section 404 then regulates wetlands, protects wetlands and the filling of wetlands. And there are sort of 5 issues or 5 processes that happen. First is what's called the delineation process. Is your particular land a wetland? And under the statute and the regulations, that is determined by its hydrology. So how much water, and the basic rule is if it holds standing water for at least 10 days out of the year, then you check the hydrology box, okay? Yeah, that satisfies that particular element. Then you look for hydric soils. What are hydric soils? They are certain kinds of soils that tend to occur in wet conditions. Okay, so there's certain kinds of soils that qualify, and so if you find that the soils are hydric soils, check that box. Third is hydrophytes or hydrophatic vegetation. Okay, this is water-loving vegetation. Certain kinds of plants tend to grow in these kind of soils, these kind of conditions. And once again, what are we talking about? Wetland, right there, it's land, but it's also water, and it's both, right? And so we're looking for what kind of vegetation goes there. So if you have that, you check that. So the land, so let's assume that you have 200 acres of land and that you want to develop. Well, the wetlands, I mean, your land might not have any wetlands. Your land might be entirely wetlands. Or the delineation might show that certain parts of it count as wetlands and other parts do not, right? Some are dry, some are elevated enough that they're not wet enough of the year, and so forth, okay? So generally, what's going to happen is that the U.S. Army Corps of Engineers is either going to do the delineation or they are going to have to be satisfied with your expert scientist's delineation. In other words, they want to make sure that whatever, if you went and paid for your own study of the property, that your expert scientist has properly delineated the wetland. Secondly, for those lands or those parts of lands that are indeed wetlands that meet these regulatory definitions, are they subject to federal jurisdiction? So this is what's known as a jurisdictional determination. What kind of wetlands, and is there some connection, as we're going to talk about, to navigable waters in some way? So that's jurisdictional determination. Third is there going to be a discharge of a pollutant? If you are planning to develop it, if you are planning to put anything in it, okay, it will be a discharge of a pollutant. Okay? So we're not talking about just toxic chemicals, right? It's not, the big chemical company spewing stuff out into the wetland. We're talking about really anything that you're adding to the land will count as a discharge of a pollutant. Fourth, is a permit available and according to what standards and processes? So this is the Section 404 permit, sometimes called the Section 404 dredge and fill permit. Okay, and we'll go into the standards and processes. And then final step is, can a citizen or citizen group sue the government regulators and or the polluter for alleged violations of the Clean Water Act? What will be the standard of judicial review? And what remedies will be available? So let's look at the regulation. So, addition of dredge or fill material into waters counts as subject to 404. Okay, the draining of wetlands by itself is not regulated by 404. Okay, so draining of wetlands by itself is not regulated by 404, but there is something called the Swamp Buster Act. Okay, it's one word, Swamp Buster, and that is if you are a farmer and you get certain federal support under various farm bills and so on and so forth you are prohibited from draining wetlands, okay? Because as a condition of the federal financial support that you get, okay? So that's called swamp busting. So 404 itself doesn't prohibit it, but the Swamp Buster Act may condition your federal financial support on you not draining the wetland. If you go in and you sort of dig up the wetlands as part of trying to drain it or whatever, okay? In general, you come in with bulldozer and you lift some of it up and you deposit it back. That is the addition of a pollutant, okay? So that's redeposit. But if it's incidental fallback, okay, so you're taking stuff out, say you're taking some water and soil out, and you're not putting it back in, there's a little incidental fallback from the machinery, okay, that is not the addition of a pollutant, okay? And don't worry about the Tulloch rule in these cases. This is actually from a time when we read those cases and so forth. The main point here is that the courts have required the EPA to draw a line. They've said incidental fallback is not what Congress meant when they said addition of a discharge, but redeposit is. And the agency has to draw some line using its expertise and considering all the relevant factors and the evidence and so forth. There's some limited exemption for the plowing of fields. Okay, basically the plowing of fields is a limited exemption. So the basic structure here of 404 permitting is, first of all, the wetland, you do the delineation, the jurisdictional determination, then you determine if the activity is regulated, if the landowner or developer then applies for a 404 permit, and they have to define the purpose of their project. What we're going to see is that definition is really important. If you are a lawyer and you are working with somebody who is going to apply for a 404 permit, you are better off, and your client is better off, if you start working with them before they ever apply, so that you can help them define the project's purpose in a way that will help them get their permit. Okay? So how the project is defined is terribly important. We'll see that in just a second. Then you look at the impacts of the project on wetlands and waters of the United States. So not only the wetlands themselves, but their impact on any interconnected or interdependent waters. So like if this means the filling of this wetland is going to be more pollution in the stream several yards away, then you look at those kind of impacts. And those include cumulative impacts. Multiple, there's going to be a lot of development in the area. We look at the, hey, we've got 10 different residential subdivisions going up. We're going to look at all of those impacts. Then you have to assess alternatives. Are there any practicable alternatives with less adverse impact on the aquatic ecosystem? Are there any practical alternatives with less adverse impact on the aquatic ecosystem? If so, you cannot get a permit. Okay? If so, you cannot get a permit. And but there's and moreover, if your project is not water dependent, so like if you're building homes or you're building a shopping mall or whatever, your project is not water dependent, that means that there is a rebuttable presumption that there are practicable alternatives. So what does that mean? There's a rebuttable presumption that you don't get any permit. Right? Okay? So this looks very daunting. Now what we're going to find is there are all sorts of ways you can get a permit. Okay, we're going to look at how you do that. But this is what the law says. This is the language in the statute. You have to minimize the impacts on the wetlands and the waters. Then you have to mitigate your adverse impacts. Okay, how are you going to mitigate adverse impacts? Well, we have a no net loss policy. What does that mean? It means that you have to create or restore wetlands elsewhere, right? Might be on your property, but you have to restore or create other wetlands, okay? And as we know, that often happens somewhere else. The general rule now is a 4-to-1 ratio, okay? So for every acre of wetland that you destroy, you have to restore or create 4 acres. Okay, 4-to-1. Okay, why? Well, partly to deal with the differences in function. We just do more because we're losing the natural function of these, okay? And to try to get some net gain instead of net loss. Well, how does this work? One way it works is that you buy credits from a wetland mitigation bank. You buy credits from a wetland mitigation bank. What is a wetland mitigation bank? It is somebody who has already restored or created wetlands and gotten certified by the U.S. Army Corps of Engineers as having X number of having credits for X number of acres of wetlands that they can sell. Okay? So let's assume for a moment that you want to develop some wetlands, and meanwhile, I have a horse farm out in Oldham County, and I have decided one way that I can actually get some money out of that horse farm, and I like it, it's pretty, it's pastures, but one of the things I can do is restore some acres of wetlands out there, or create some acres of wetlands out there, right? Horses like it, fine, good, right? And so I create some acres of wetlands, and I go to the U.S. Army Corps of Engineers, and I get certified for that. And I turn myself into a wetland mitigation bank. Okay, so we're not talking about, you go down to Fifth Third Bank, right? That's not what we're talking about, right? We're talking about, I am the holder of these credits. That makes me a wetland mitigation bank, and you can come and buy those credits from me. So, but here's the thing, is if you want to develop 20 acres of wetlands, you're really hoping that I have created 80 acres of wetlands out on my farm, right? Does everybody see that? And if I don't have 80 credits to sell you, you may have to go to multiple banks, right? You may have to buy, 20 from me and 40 from somebody else, and so on and so forth, right? You get the idea, okay? So that's how that works. There's some processes and terms and conditions that we'll talk about in terms of the permit decision. As I mentioned before, the EPA has veto power, and there's an enforcement mechanism. There are various enforcement mechanisms, including civil suits by citizen groups. Okay? So we're going to spend some time talking about which wetlands are subject to federal jurisdiction under the Clean Water Act. And so the constitutional foundation of all this is the Commerce Clause, and you should all be familiar with the Lopez test, right? Right? Commerce Clause, yes? You're like, oh God. Okay, so, all right, but, okay, I promise you though, environmental law is easier than Marcuson's common law class, so don't, yeah. But this is the basic, right, where Congress's Commerce Clause power includes regulation of the channels of interstate commerce, regulation of the instrumentalities of or persons or things in interstate commerce, and activities that substantially affect interstate commerce. So this is the basis for Congress's authority to protect the waters of the United States. Well, some waters are obviously channels of interstate commerce and their use and development are activities that affect interstate commerce. What waters would those be? Those would be navigable waters, okay? We use navigable waters in interstate commerce. So all navigable waters count, okay? And that is true if they have been historically navigable. Okay, so there's a case, I think this was Utah or Montana or someplace or other, Idaho, one of those places out there. But the point was, if historically the timber companies floated a log down the stream, that makes it navigable. Okay, and so therefore subject to the Congress's authority to protect. Okay, but wetlands are never mentioned. Right? Wetlands are never mentioned in the statute, and so it talks about waters. But if we don't protect wetlands, we are adversely affecting navigable waters. But the question is, how many wetlands? Where? What kind? So in terms of defining the reach of 404 jurisdiction, we look at the statutory language, we look at the language of regulations that the agencies develop, case law, and then also the U.S. Constitution, where the limits of congressional power. So here's the Clean Water Act. Right? Any pollutant to navigable waters from any point source. Navigable waters means waters of the United States, including the territorial seas. Okay, so the thing I want to point out to you is the Clean Water Act is immensely unhelpful in defining its own scope, right? This is part of why we have so many cases and so much conflict over this is, okay, waters of the United States are navigable waters, and navigable waters are waters of the United States. That doesn't help us at all, okay? Before a case called Rapinos, the Corps had a set of regulation which said it's a bunch of other, it's obviously navigable waters and interstate waters, but also other waters, including wetlands and so forth, prairie potholes and wet meadows, et cetera, the use, degradation, or destruction of which could affect interstate or foreign commerce. Okay? By the way, notice natural ponds. What does that leave out? Artificial ponds, humanly created ponds, right? So we're not regulating the pond that you create yourself, okay? Tributaries of jurisdictional waters, wetlands adjacent to waters and tributaries, and ephemeral streams and drainage ditches with perceptible high water mark. Okay? So this is before Rapinos. So lots of things count. And so this is where you have a wetland that is adjacent to a lake. If you fill that wetland, it will have a direct adverse effect on water quality in the lake. Okay, we know that. There's no question about that. If you fill that wetland that is immediately adjacent to the lake will become more polluted as a result. So here's a non-navigable stream that is a tributary to a navigable water. So this is a lake, it's a non-navigable stream. Non-navigable stream is a tributary to a navigable water. Okay, this is basically the Mono Lake case, right? Those feeder streams were non-navigable, but the public trust applied to them because they were the source of water of Mono Lake, which is a navigable body of water. Okay, right? Does everybody see that issue? So, but then what happens when you have a wetland that is near but not immediately adjacent to a navigable water? Does that count? Right? Aha! The plot thickens. Okay? What happens when you have a wetland that is connected by a channel, a humanly created channel that goes to a navigable water? Does that count? More questions. So, our history with the Supreme Court starts with all the way back in '85 with Riverside Bayview Homes. where the Corps' interpretation of waters of the U.S. as including adjacent wetlands, wetlands that are adjacent to navigable waters, that's reasonable. And it was part of a larger wetland area that was adjacent to the navigable Black Creek. And the Supreme Court says Congress intended to regulate wetlands adjacent to navigable waters because they are inseparably bound up. Okay, so that's a good phrase that they said, inseparably bound up with the waters of the United States. Okay, and so therefore the Corps' interpretation of the Clean Water Act is reasonable. Right? So you're looking at the language of the Clean Water Act, you're looking at the scientific evidence of the ways that adjacent wetlands affect navigable waters, and the court is deferring to the interpretation by the agency, Chevron deference, right? It's a reasonable interpretation to say that adjacent wetlands are Congress intended adjacent wetlands to be regulated. Then you get the Swank case, Solid Waste Agency of Northern Cook County. And the Swank case had to do with a gravel quarry in the Chicago area. Okay, so first of all, it's Chicago, right? Okay, all right, so I have biases, but it's Chicago. It's cold, it's, it's corrupt, it's Chicago. Mm-hmm. All right, but aside from that, it's a gravel quarry. Okay, it's not anywhere close to any navigable waters. Okay, they dug gravel out of it, but they quit digging gravel out. What happens? Over time, water fills. Okay, and Chicago's not Las Vegas, right? There's going to be plenty of water that ends up in that quarry, in the bottom of the quarry, over time, and it's become like a little lake or pond or reservoir in the bottom of it. So what's going to happen? That water is going to have that quarry is going to have standing water for more than 10 days out of the year. Hydrology, check. Okay. It is going to have soils that hold that water, hydric soils, check. And what's the third thing that's going to happen? Over time, you are going to find growing in the bottom of that quarry hydrophytic vegetation, right? Or hydrophytes, right? Check. We got all three. It counts as a wetland. But is it subject to federal jurisdiction? Okay? And so the Army Corps of Engineers says yes, because part of what we're doing here is implementing our authority under the Migratory Bird Treaty Act. Okay? So now we're down to the international treaty power and so forth. And there are interstate and international migratory birds that are flying around, and they're looking down at this gravel quarry and saying, hey, I'm going to come down here and, eat some whatever, grubs or whatever's in the water, or I'm going to I'm going to hang out there, I'm going to nest there, I'm going to bathe there, drink water, whatever. Okay? So it's being used by migratory birds. And the Supreme Court says, nice try, kiddo. This is of course not. This is not navigable waters. Okay? Gravel quarry is not waters of the United States. It is beyond Congress's intent to regulate, under the Clean Water Act, this isolated gravel quarry that has become wet simply because some bird might look down and land there. Okay, so that's not enough. And they said it was the significant nexus between the wetlands and the navigable waters that informed our reading of the Clean Water Act and Riverside Bayview Home. So that starts giving you some sense of where they're going. Okay? So now we go to Rapinos and Carabel. So this is 2006. So companion cases. And Rapinos is a developer who filled 54 acres of wetlands without a permit and in defiance of an order from the Corps and a cease and disorder from the state. So they got into a lot of conflict and so forth. And there were 3 sites that had wetlands that bordered on or had a surface hydrological connection to the Pine River, which was non-navigable, or other non-navigable tributaries of navigable waters. And so the Corps says, hey, the wetlands don't need to be directly adjacent to the navigable waters. They could be adjacent to a tributary. And so there's some bad actor stuff going on here with Rapinos. There's a consultant, and Rapinos orders the consultant to destroy the report because he didn't want to be subject to this. So this is a little bit like the shoot, shovel, and shut up kind of thing we talked about with the endangered species, right? He's trying to get out of this. And there's civil and criminal legal actions brought against Rapinos. And the Sixth Circuit found the wetlands to be jurisdictional. Now, y'all know that the Supreme Court picks certain cases based on the facts of those cases. If they have decided they're going to make some sort of pronouncement, or they're getting ready to make some sort of pronouncement about the law is this, or their law's changing, or whatever, they find certain things. So, right, y'all know that Brown versus Board of Education, they made the lead case Topeka, Kansas, for the very point that, okay, if we have segregated schools in Topeka, Kansas, right? We're not talking about Alabama. We're talking about Topeka, Kansas, right? Then, you know, this is a issue that we're going to address nationwide, right? Okay, and Lucas versus South Carolina Coastal Council, right? The takings case. They purposefully picked a case where the trial court had found that the land had been rendered valueless by the regulation. Why? Because it's a factual finding, and all the appellate courts, including the Supreme Court, are bound by those factual findings unless clearly erroneous. So they sat there for a few years waiting for the right case to come to them for those facts. For women, well, if we were right, but the case that they wanted, the facts that they wanted. So one of the things I think is going on here is Rapinos has been criminally charged for violating the Clean Water Act. Okay, so I think part of what they're saying is, hey, you know, you might go to jail for developing your wetlands that are not, adjacent to navigable waters. Can the Corps do that? So Carabel was a little bit less salacious case. There was but the facts here are the wetlands were physically proximate to but separated by a berm from a tributary to a navigable, in fact, water body, and the navigable, in fact, water body was about a mile away. And there's a ditch and so on. Okay, so here's a picture of one of those scenarios. And so here's Rapinos on his property. That's the wetland. Right, that's an overview of Pine River. So you see the Pine River, there's non-navigable stream. This is where Rapinos is developing. So, right, we're no longer talking about the gravel quarry, right? I mean, so this is development right along this stream, which is going to end up in a navigable water. And this is where he dredged the ditches and filled the wetlands, and this is drainage ditch, and this is Carabel's wetlands. Okay, so what was the outcome? So it was 4-1-4, okay? And so Scalia, Roberts, Thomas, and Alito were the plurality, Kennedy was the concurrence, and Stevens, Souter, Ginsburg, and Breyer were the dissent. Okay, so plurality. So they say wetlands are waters of the United States only if the adjacent channel contains a relatively permanent body of water, okay, so no intermittent or ephemeral flows, and that is connected to traditional interstate navigable waters, and the wetland has a continuous surface connection with that water, making it difficult to determine where the water ends and the wetland begins. Okay, so that is That is what the Supreme Court, the plurality says that Congress intended in terms of wetlands that count as waters of the United States. So basically they're saying you have to have some continuous surface connection to waters, to navigable waters. Okay, so they say, hey, seasonal rivers count. Streams, rivers, or lakes that might dry up in extraordinary circumstances, such as drought, count. But intermittent or ephemeral flows in channels do not count. Well, not going to be wet meadows, storm sewers and culverts, directional sheet flow during storm events, drain tiles in dry arroyos in the middle of the desert. Justice Kennedy is the swing vote here. And Kennedy concurs in the judgment of the court and would define waters of the United States as waters that have a significant nexus to traditional navigable waters. And significant nexus means the ability to affect the chemical, physical, and biological integrity of traditional navigable water as determined on a case-by-case basis. Okay? So remember I told you that the purpose language about the intent to restore and maintain the chemical, physical, and biological integrity of the nation's waters, okay, that has legal significance. And lo and behold, here it appears in Kennedy's significant nexus test. Okay? And that is regardless of whether they have a direct surface connection, regardless of whether they're adjacent. So Kennedy says we've got to do a case-by-case analysis to determine whether these wetlands have a significant nexus in terms of the ability to affect the chemical, physical, and biological integrity of navigable waters. Okay, so what he's saying is, if we fill these wetlands, what kind of impact is this going to have on navigable waters? And that should be the focus, regardless of whether there's a direct surface connection, regardless of whether they're adjacent. Stevens, Ginsburg, Souter, and Breyer would defer to the agency's interpretation under the Chevron doctrine, and they basically reject both Scalia and Kennedy's interpretations. So they remand the cases, okay, typical approach. And what happens for several years after this is that there's enormous confusion over federal jurisdiction and which legal standard to apply. So one of the things that goes on for a while in federal district courts and federal appellate courts is, do you apply the Scalia test or the Kennedy test or both? Right? Do you have to have some direct surface connection? Do you look for the significant nexus? Or if it meets either one? Is that right? I mean, so you've got three options, right? And the courts are all over the map in terms of what they're deciding. Okay? Now think about this, all right? Right? For our problem, you are representing the Kentucky Farm Bureau. What do Kentucky farmers think about this enormous uncertainty? Right? They hate it, right? They hate it, right? I mean, they don't want to be regulated, but the uncertainty about which rule applies, how the court is going to determine this, whether if the court does one thing, would they be successful if they sue, whatever, right? And even more so for developers. Okay, the developers hated it even more because time is money for the developers, right? They're eager to move in having all this uncertainty about what test you're going to apply to determine jurisdiction, right? Jurisdictional determination was a problem. So, and there's a lot of conflicting decisions. So one of the things is, the agency eventually creates a guidance and so forth. So I'm going to keep going on that. Okay, so here's the ways in which, this is just a diagram to show that there's a possibility that you could fall into one your wetland might fall into one category but not another, and so forth, okay? Chief Justice Roberts says, hey, you know, this is going to be difficult. Chief Justice Roberts tried to steer everybody towards basically use the Kennedy significant nexus test, right? Marks versus U.S. and Grutter versus Bollinger. The holding of the court may be viewed as that position taken by those members who concurred in the judgment on the narrowest ground. So Chief Justice Roberts, right? He's an institutionalist, right? He's concerned about the integrity of the judiciary, right? You might agree with him, you might disagree with him, but the way he approaches things is he wants to sort of say, hey, the courts are the sort of, you know, I don't know, neutral institutions, and you should respect us, and we deserve your respect. And so part of what he's trying to do here is send a signal to everybody, you should use Kennedy's significant nexus test. Okay, that's not what's happening. Okay, the reality is everybody's all in confusion, but that's what's going on there. So there's a split, blah, 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 blah. It says currently, that's no longer true, but ignore that. Okay, so one of the things that comes along is the Clean Water Restoration Act, which tried to define the waters of to basically amend the Clean Water Act and to define it very broadly without any limitation as to interstate commerce. Okay? It never got anywhere. Okay? So the best that happened is I think it got out of the House committee, but never even made it to the floor of the House of Representatives. And by the way, this is happening during the first 2 years of the Obama administration when the Democrats controlled the House, the Senate, and the presidency. And it never got anywhere, okay? So it tells you it's not gonna happen, right? I mean, it's just not gonna happen, right? The politics of it is not there, and there's some questions about whether if you strip the Clean Water Act of any connection to the Interstate Commerce Clause, whether that is even constitutional. So the Corps tried to do some sort of guidance, and that was sort of a mess. And then they tried to do another guidance, and that was sort of a mess, case by case, significant nexus, blah, 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 and so forth. And so eventually what happened is they adopted WOTUS, okay, Waters of the United States Rule. Okay? Now, one of the things that's going on during this time frame is that there are applicants for 404 permits who are waiving the jurisdictional determination. They're basically saying, hey, if we have wetlands, we're just going to admit to you, the U.S. Army Corps of Engineers, that these are subject to federal jurisdiction. Please go ahead and process our permit application. Why? Because it was taking more than a year for the Corps to make jurisdictional determinations using these guidances, okay? And again, time is money, so these developers, these landowners did not want to be regulated, but they would rather just get their permit than be caught up in this sort of uncertainty and be in a holding pattern while they're waiting for the Corps to decide whether there's federal jurisdiction. Okay, so there's this big, huge scientific report, Connectivity of Streams and Wetlands to Downwater Streams, which reviewed and synthesized more than 1,200 pieces of relevant peer-reviewed scientific literature, which is actually what you're going to have to do for the final on this custom piece. But it tells you something about what happens in environmental law, right? I mean, the agency studied 1,200 or more scientific studies in order to come up with WOTUS. And it's it was a very extensive rule, okay? And they adopted it according to notice and comment rulemaking. Notice and comment rulemaking. Having said that, there was a big difference between the proposed WOTUS rule when they first issued the notice, right? They issued a notice to engage in a rulemaking, and they issued a proposed rule, and they got comments, and based on the comments, they came up with a very different rule in the end. And you're going to see that that's a problem. Okay? So, and you don't have to pay attention to too much of this because in part it's no longer, it's been repealed. Okay, so but it's very broad, blah 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 blah, very broad, blah 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 blah. Okay, so legal challenges. Okay, lots and lots of things counted, but they used the direct connection and the significant nexus and found lots and lots of things had a significant effect on the lots and lots of wetlands had a significant effect on the chemical, physical, and biological integrity of navigable waters. And so part of what they said is, if your wetland is within a certain amount, I think it's 500 feet, of a navigable water, it automatically had a significant nexus to that navigable water. Okay, so there was these broad rules. It got challenged. And so on one hand, it established bright lines that the regulated community and the regulators wanted, but it was very broad and applied to lots and lots of wetlands, and so a lot of states sued. Okay, and so you had one group of states that sued in the Federal District of North Dakota, and they said, hey, the case-by-case analysis applied to remote and intermittent waters that do not directly bear on navigable and fact waters. The definition of neighboring wetlands was not a logical outgrowth of the proposed rule, so there was there for lack of notice, and there was no EIS prepared in connection with the rule. So, preliminary injunction in these 13 states. Then the Sixth Circuit, right where we are, and you can see Kentucky was a litigant, enjoined the rule nationwide in 2015, and they said, again, the proximity element was not a logical outgrowth of the proposed rule, and it's inconsistent with Rapinos. And then here in that's 2015, in 2019, Texas versus US EPA, the federal district court says, again, not a logical outgrowth. The notice and comment rulemaking was not followed because there was inadequate notice to the agency, to the public, that they were going to adopt this neighboring wetland definition. Okay, so those are the lawsuits. But there's just recently, I mean like in the last 2 weeks, decision from the 10th Circuit that asked the parties to brief whether or not all of this litigation has been rendered moot because relatively recently the Trump administration, the US EPA and Army Corps of Engineers together have repealed the WOTUS rule. Okay? So they have repealed the WOTUS rule and replaced it with the pre-WOTUS definition of navigable, of wetlands that count as federal jurisdiction. Okay? And their intent, they initially said their intent was to replace it with a more permanent rule down the road and have this listening tour and have lots of notice and comment. The future of a permanent rule is uncertain because they seem to have kind of backed away from doing anything about that. I don't know if that's a matter of time or what's going on with that, but the bottom line is WOTUS has been repealed by the administration, and so the old definition is back. Okay, why do we care about this for our problem? Here is a map of along the Gulf of Mexico, so here Texas, Louisiana, Mississippi, Alabama, Florida, that shows coastal wetland loss. There's subsidence, right? Sediment deposition, so soils filling them up, and development. And so you see down here where the Mississippi River enters the Gulf of Mexico, right, we have between 2,500 and 4,500 acres of wetlands that have been lost, okay? So what does that mean? It means that all those nutrients that are coming down here are not being filtered out by wetlands that historically would have filtered them out, right? Okay, does everybody see that? That's the bottom line. So one more, this is our last slide. And so the other thing is, what about upstream wetlands, okay? Is it possible that we could prevent the nutrients from ever getting in the Mississippi River by using wetlands to filter them out? And the answer is yes. And look right here in Kentucky, right? There's some significant, efforts to restore and conserve and protect wetlands. And there's something called the Sturgis property, which is this huge, massive timber company property down by Sturgis, Kentucky, okay, that has been acquired by the Nature Conservancy, that is basically being restored into a nutrient filtering out massive wetland right there on the riverbanks. Okay, so that's one of the efforts that's underway. So something to think about as you know, and then like where does the funding for that come? How effective is it? How do we deal with things like climate change and protect those and deal with other sorts of sources? All right, so that is wetlands. See you on Wednesday.
Good luck on your test.